The first case to come before us this morning is State of Ohio versus Stephen Zink. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve any time, let me know when you get started. I'm keeping the clock this morning. Please don't use the names of any victims or minors, as we are live streaming this video and it will also be posted on the court's YouTube channel. We've read the briefs and we're ready to proceed when you are.
Good morning, Your Honors. Giovanna Bremke on behalf of Mr. Zink, Stephen Zink. I would reserve 5 minutes of my time for rebuttal. My client in this case was charged with 2 counts, one of felonious assault, one of assault. And it's both parties were at a bar. It's not your traditional bar fight because my client was working. He was the bouncer more or less at the establishment. And the complaining witness was a patron. Basically the patron was sort of getting out of control. My client asked him to leave, and at one point, my client had said that the patron's wife had gone after him, and he acted in self-defense. A key component to this case, and you'll see it throughout the transcripts from both the state and the defense side, was intoxication of the complaining witness, SS, we'll call him. And I don't think it's very much disputed that my client, because he was working again, was not intoxicated, but there was quite a lot of testimony about SS being intoxicated. Which brings us to our first assignment of error, and that's that the judge commented on the evidence in violation of the 5th, 6th, and 14th amendments. Essentially, and you can read in the transcript, pages, I think I'm missing a number here, ends at 203, but it's also in both of our briefs. But the conversation was surrounding the testimony of the complaining witness. And that's important because I go through the 5 Wade factors, which is the case that sort of controls this sort of issue. And, one of those is sort of the way in which the evidence is presented, or when it is presented. And so what we know about self-defense, all of us in our experience, is that that's sort of the key here, because a lot of this ends up being he said, she said, what one person felt versus what the other person felt, and whether there was a reasonableness to that self-defense. So this presented itself during the testimony of the complaining witness. The defense was trying to elicit information regarding his level of intoxication. And he had asked about some medical records that said that witness was acutely intoxicated and what that meant. The judge sort of interjects and says, well, acute isn't severe. They, and sort of alluded to the fact that the acute part of it was not towards the level of intoxication, but more towards contrasting that with whether it's chronic or acute. What it had turned out is that there was, a definition of acute, and it did pertain to a level. The defense counsel objected, and that objection again is outlined in the counsel had said, hey, you're interfering with my ability to cross-examine this witness. And the defense counsel, ironically, had a case very factually similar in Lorain County in the 9th District, and also had to do with a bar fight several years ago. It's called State versus Luciano. And he says to the judge, hey, I've had this case before and with a different judge, but, your comments about the evidence are, prejudicing the jury. And this is, by the way, in front of the jury. So Luciano basically goes in, I cite Luciano in the factual situation of that in my brief, but again, it's very factually similar, the two cases. But Luciano goes through the 5 Wade factors. So one of those is prejudice placed on the defendant. And I know that's something that is talked about also by the state in their brief. So, the prejudice is severe here. And again, I think when we're looking at self-defense and when we're relying a lot on witness testimony, right? There's not a lot of physical components to a self-defense case. There's not a lot of DNA testing or drug testing, things of that nature. In a self-defense case where the witness testimony is extremely important. And the reason intoxication is important is because the intoxication of the complaining witness is a indicator of how reliable that witness was to the jury, of whether his recall of that night. And again, my client, and I don't think this is heavily disputed in the transcripts, was not drinking that night. He was there working, or was not intoxicated that night. And so his
counsel,
yes,
because you have limited time, let me just ask you, like you mentioned, the state does say in its appellee's brief that, okay, let's say that wasn't proper. Where is the prejudice in regard to the fact, since the judge did instruct the jury that he was intoxicated above the legal limit, which I'm not even sure should have come in, but regardless. So isn't that even better whenever a judge instructs the jury that somebody is above the legal limit, because everybody knows about that, and meaning you're impaired and you can't drive. So how does that not, obviate the prejudice?
Well, I'm glad you brought that up, because the Luciano case, there was also what I would consider an attempt at a curative instruction, which there was also an attempt here. But in both cases, there's not, in this case particularly, there's not ever something that says, hey, disregard that I said that there wasn't severe intoxication. There is a mention, and it is a strange instruction, I agree with you, about the level of intoxication being more than that of whether somebody can drive. And I still think that it prejudiced the jury, because this is at a key component, and that is one of the Wade factors, the time in which it's presented. I think that's the third factor, the light of the circumstances in which it's presented. And so during the key cross-examination of the key witness here, that's when the judge interjects in this later instruction about being, not being able to drive. I think that's different than the perception of being able to, of presenting itself. Additionally, the defense counsel says, you're prejudicing my ability to cross-examine this witness. So defense counsel's cross-examination could have gone significantly different than, if he would have been able to elicit that evidence. So that could have cut short his cross-examination. Speaking of cut short, I know I'm probably short on time. So I'm going to reserve the rest of my time so that I have some time to come back. Thank you.
Thank you, counsel. You'll have 5 minutes when you return. Counsel for the state.
Thank you, Judge. May it please the court. I'm Rick Raley, appearing on behalf of Lorain County Prosecutor J.D. Tomlinson in the state of Ohio. And I think that this court should affirm Mr. Zink's conviction and sentence in this matter. Based on what the presentation this morning, I'm going to also focus on the first assignment of error. And to me, I think that it's pretty clear, looking through the transcript, that the judicial comments from the trial judge were quite benign and not at all to the level that we addressed previously in Luciano from this court. The judge essentially just raised an issue of, well, acute's different from severe and chronic. And then instead of actually even defining those terms, they went to sidebar and further discussed the objection from the trial counsel, and they went over that issue.
Counsel, would you agree as a starting point that it was improper for the judge to make the comments?
I would prefer that he not have, of course, Judge, but I don't think that it rises to the level of legal reversible error or some sort of, even error, I would say. He was almost thinking out loud about how to handle an objection. And then when they had to have the in-depth conversation, they went to sidebar.
Yeah, but even talking out loud, we can't, as judges, we can't talk out loud as to what we think the evidence is, can we?
Right. Well, there was no commentary on the witness credibility within the comment. That's why I don't think it rises to the level of being even impermissible. When I look through the Luciano case, this court described the judge had commented multiple times in front of the jury about his conclusion he would reach based on the witness's testimony. I do not see that in this exchange. It's about page 199 to 200 of the trial transcript. And in fact, the curative instruction that is given afterwards, I think actually bolsters the defense's theory. It pretty much instructs the jury, hey, find the witness, the victim in this case, was legally intoxicated. And I would strongly disagree with the characterization that this somehow impacted or reduced the ability of Mr. Zink to cross-examine the complaining witness. In the course of cross-examination, the complaining witness admits, I had a buzz. He also acknowledges I was diagnosed at the hospital with acute alcohol intoxication. This evidence was clearly given to the jury to decide. The judge even bolstered that evidence by telling them, hey, this is over the legal limit. And they took that and they considered it with their deliberations. So I really don't see how there's prejudice from the comments. And I think because of how reduced they were and because there's not a comment on credibility here, I don't even necessarily rise to the level of being impermissible.
The other thing, counsel, let me just ask you, because I was a little confused as to how this happened. You seem to be indicating that this was an agreed upon instruction to the jury.
Yeah, so what appears to have occurred is that there was a break in the trial, and when they come back, it came out, well, the medical records of the victim are going to be admitted into evidence, and it actually includes what his BAC was at the time of his hospital admission, which was 0.085. And based on that evidence that was going to be submitted to the jury, the defense lawyer at trial counsel said, hey, let's have this curative instruction, let's include this, and they came up with this together, and it was given to the jury. So really, to me, initially the defense lawyer at the trial level asked for a mistrial. It almost seems as though that approach was abandoned, and it's like, hey, how about I get this curative instruction instead? And he got what he wanted from the judge. And there was extensive argument at a closing argument about the witness's intoxication, which was their theory of the case. There is no prejudice here. And just to address, I guess, quickly the second and third assignment of error. For the second assignment of error, I think that there is a legal issue in front of this court about whether it should consider evidence regarding self-defense under sufficiency analysis. That is an issue that's currently before the Supreme Court in the Messenger case. When I look at the felonious assault statute, I don't see that the essential elements of the offense include the lack of self-defense. So I do not believe that it is something that this court should consider under a sufficiency analysis. And every court of appeals that has addressed that issue so far has said that those issues should be decided under manifest weight. And under either one of those standards, though, I think it's clear there's no reversible error for the state's evidence based on the lack of self-defense. It's very clear that from the evidence that the state has presented evidence indicating that the defendant was the initial aggressor, he used unreasonable force, and it was not closely calibrated. In fact, he admits to a lot of that as I mentioned in my brief. So if there's no further questions, I would just ask that this court affirm the trial court's conviction and sentence.
Seeing none, thank you, counsel.
Thank you, Judge.
Can I back up?
Yes, Attorney Brimke, you have 5 minutes.
Okay, so I wanted to address some of the weight factors because one of them that I believe it was Judge Carr mentioned in asking the state, hey, don't you essentially, and I'm paraphrasing, agree that these remarks were inappropriate, they shouldn't have been said. And the second factor is that the trial court judge is in the best position to determine that this, whether a breach has occurred. And we know that the trial court does agree that they shouldn't have been said because there was this suggestion of a curative instruction, which again, I will present to you as a curative instruction that failed to be curative instruction, but the trial court.
Counsel, I'm sorry to interrupt you, but was it an agreed upon curative instruction?
Yes, so I will get there. So the curative instruction in what it is with the legal limit and the driving and all of that was not, this language was not something that was agreed to. There was a talk about more, about further defining acute, but this specific language, I think, again, the judge, the trial court sort of put in some additional commentary in the curative instruction. There was talk about instructing the jury in the jury instructions, and I won't dispute that. But this is not, this paragraph, which is page 259 through 260, which I will say is what, we have sort of defined as the curative instruction, is not something that was agreed to in whole. I also would submit to you that that's sort of a red herring, because this level of intoxication being too much to drive is a factor in an OBI case, but it's not a factor in this case. So, that is, something that, although the trial court sort of, addressed that, really is different than when the defense attorney was trying to cross-examine about the level of intoxication. And the reason why I believe that they were cut short is the natural progression of that is saying, okay, you were acutely intoxicated, you were too intoxicated to recall these events, but being cut short of that and being undermined as far as the level of intoxication is deadly in this case to a self-defense argument, which is the sole defense here. I mean, that was what it came down to, is self-defense. So I do think that that's important, and it certainly shows prejudice, which is the first weighted factor. The second one, I think the court decides for you, and because the court agreed that it was inappropriate by later suggesting a curative instruction. The third was the light of circumstances in which that this is, in which the arguments were made, and again, we went over this in that the defense attorney is cross-examining the main witness here. So that's certainly sort of the key component here of the trial. And the fourth and fifth factors are the effect on the jury and the impairment of the defense counsel to be effective. And again, it's page 201, the attorney says, you're prejudicing my ability to cross-examine this witness. So again, that's decided for you. There's, that's a pretty, 2 and 5 should be very easy. And the effect on the jury, again, this is during a very critical part of the trial in which there is discussion about this. As far as the other factors, again, I think the reasonableness in light of the trial, in my client's ability to maintain the entire bar. He's working as a bouncer. Their entire jobs are to maintain control of the bar. Having an individual get out of hand is certainly, an inability to protect the others, because if he goes down, sort of the ship goes down, has the potential of going down altogether. So I think that reasonableness is something that needs to be considered. Given all of that, I would ask that you reverse the judgment of the trial court. Thank you.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision, which we mail to all parties to this appeal, as well as posted on the Ohio Supreme Court website.